everyone, I am attorney Didem Taylan from White Yellow Office. Today, our founding partner, attorney Mert Yalçın and I will be discussing international child abduction. Hello, Mr. Yalçın.
Hello. How are you?
Fine, thanks. How are you?
Good, very good. Sunny day. We are all good in lovely Istanbul.
Yeah. And Mr. Yalçın, as a practitioner in this field, could you explain to our audience what exactly international child abduction means?
Thank you. International child abduction means, naturally, it is international elemented action. So one of the parties should be resided abroad. And also, if we are talking about international child abduction, there should be specific requirements under the Hague 1980, which is defining in detail international child abduction and related topics properly. In the light of this convention, I might tell you that in order to speak about international child abduction or retention, there should be a child, and also this child needs to be under age of 16, and both parents needs to have a joint or court-designed custody rights related to child, and the child needs to be removed from the habitual residence country without a consent or approval of the other parents. If the other parent does not have any consent, any confirmation about the relocation of a child, then left behind parent is free to run Hague 1980 procedure through the central authorities. So to summarize, we need to have a custodial arrangements which allows to left behind parents to apply asking return of a child to habitual residence country within the specific time period, within the specific age. So in the convention it is stated that the application needs to be done within 1 year of the abduction or retention date, and the child shouldn't be over 16. So if one of these conditions are not valid in the application should be rejected, dismissed by the local central authority.
And thank you for clarifying. And my next question is, how does the application process work?
Well, it's very important point, because in the convention, in the Hague 1980, it is clearly stating that the central authorities are running the procedure. And for example, for Turkey, the central authority is the Ministry of Justice, and in the Turkish Ministry of Justice there's a special department. So you need to fulfill the form, and the form is also a standard form which contains basic information about the parties, about the child, about the information on where the child was living, what was the school, what was the health activities. So you need to provide as much as detailed information you can. This is important. Why? Because through the central authority, your file will be sent to the other party state central authority. For example, let's put a mood case in that video, and let's assume that the Turkish American couple living in New York, and the party is divorced in New York, and within the divorce decree there is a joint custody regulation, and the Turkish American mother got a consent letter from the father stating that the child will spend her or his holiday in Turkey limited with 15th of July, 15th of August. And the child flew to Turkey right here, his or her mother, and the mother sent an email to father stating that they decided to live in Turkey and file the divorce case in Turkey if there is no divorce, or file change of a custody case in Turkey, and there is a court order preventing child to travel abroad, which is called travel ban as a temporary order. So that's a mood case scenario. In that case, left behind parent, father, needs to apply to US Department of State as the central authority. And Department of State will transfer the file to Turkish Ministry of Justice as a central authority, and Turkish Ministry of Justice will examine the file and then send the file to local public prosecution office. A local in here means where the child is located. For example, in our mood case, the child is in Istanbul. So Istanbul, let's assume that İstanbul Çağlayan Courthouse public prosecutor will invite the abducting or retaining parent, the mother in our mood case, for an amicable settlement meeting. This is the first level of the procedures under Hague 1980. So within that settlement meeting, the public prosecutor, on behalf of the central authority, will ask retaining party, the mother, to return amicably back to habitual residence country. And the mother, in that mood case, would either accept it and go back, or would simply deny and say, okay, I have a change of a custody or divorce case in Turkey, and Turkish judge put a travel ban in that file as a temporary order, so I'm not gonna fly back. We are already divorced, or we are currently divorcing in Turkey, so I want Turkish courts proceed with the further examination. That's a very basic mood case scenario. This is what we see in almost 60-70% of all these cases. The important points are, first, habitual residence. What is habitual residence? This is the very first condition of determining the abduction or retention. Habitual residence is defined in number of books and theoretical sources, and also a lot of Supreme Court orders defining that. The habitual residence is the place that the concentration of child's life. This means that in our mood case, the child was going to school in New York, the child was going to a doctor in New York, the child have had all friends in New York, so the child came to Turkey temporary basis. So in the light of this basic information, I might straightforward say you the habitual residence is New York, USA. And also we have much more complex situations. For example, imagine that the child is living in two countries, 160 days in Turkey, the 205 days in America, and the child has school in both countries. The child has doctors in both countries. In that case, we have to fully concentrate and understand the concentration of child's life. Where is a real place that the child really engaged to? This is very important. This is not a straightforward answer. Every case has its own spirit, so everything needs to be properly examined under each file separately. So there is no concrete definition of habitual residence, but we can define where is habitual residence with the information that we got from the file, we got from the situation.
And Mr. Yalçın, I'd like to ask, do you believe the habitual residence is always in the best interests of the child? So, life is complicated.
Well, best interest of a child is the primary sentence of entire multinational conventions on children's rights. So, best interest of a child is always on priority. So, the habitual residence is something needs to be decided with the evidence, with the real facts. This is something we can decide through the proper data. This is something we cannot just estimate quickly. No, we need to examine child's life concentration and all supporting aspects separately and together. So this is important. Of course, it is important to define the habitual residence because the habitual residence is the key factor of applying the Hague 1980. Otherwise, the application or case will be dismissed.
Yes, thank you for your answer again. And I'd like to ask one of the most common questions. Is child abduction considered a crime?
Well, in Turkey, this is alternatively arranged with the Turkish Criminal Code. And if the non-custodial parent is hiding the child and trying to escape or trying to relocate, then this will take us to either non-applying the court order or also retention of abduction parent due to illegal removal of a child. Because if there is a court case and court order stating that, for example, the custody of a child with the age of 12 belongs to a mother and the father goes to somewhere else and hidden place and not bringing the child back, of course, this will gonna have criminal aspects locally in Turkey. International wise, yes, you can process the internal procedures, internal court applications, both civil and criminal courts. However, if there is an abduction, my humble advice would be to immediately interact the Hague 1980. Of course, Hague 1980 is not the only convention. There is also Hague 96. 96 is also a convention on the same subject. However, this has a very wide coverage than Hague 1980. And in Turkey, if there's any temporary order, any kind of protection order in the civil courts, the public prosecution office will immediately reject Hague 1906 application. Of course, each case has a different aspect, different evidence, different spirit. So we need to think about everything separately.
Yeah, of course.
So that's all. I want to add one important thing about what is the return case, because I provided the information about the amicable settlement meeting, which is done in the public prosecution office in the, for example, Çağlayan courthouse in our mood case. If there is no settlement, the minutes of meeting will be taken and the signature of the abducting or retaining parent needs to be taken by the public prosecutor, and then the public prosecutor will inform the central authority, the Turkish Ministry of Justice, stating that there is no amicable settlement as per the convention. So the next step will be to file a return case by the public prosecutor in order to realize, in order to apply the convention rules. Once it is filed, the return case needs to be completed as soon as possible as a priority file. In Turkey, unfortunately, we are not able to keep the 6 weeks timeline, which is defined in the Hague 1980, due to heavy workload in the court house. Unfortunately, most of the judges cannot comply with this 6 weeks period. So with my experience, I can tell you that depending on the file, because again the application must be prepared properly with all translations, with all supporting evidence. And also you need to hire an attorney, an expert attorney, to follow up your process. This is not mandatory. Even though you don't have any attorney, the public prosecutor needs to follow your file, even you do not come to hearings in Turkey. However, in order to properly define and put forward proper evidence, right evidence, my advice will be hire an attorney and control the file and submit rejoinder petition once the return case is filed. Because with the rejoinder, what we do, we provide all the background information in detail. We provide all supportive arguments in detail, and also it is good to follow up the procedure both in central authorities and the local stages. That's why it is important to hire a lawyer.
Yes, thank you. Another common question is, does filing for divorce or a change of custody affect the return cases?
Well, this is very standard strategy which most of the Turkish colleagues are dealing with. However, I don't recommend it because Article 16 of the Convention is very clear. Turkish authorities, as a party to Hague 1980 Convention, cannot move forward with any custodial decisions. So in such case, what happens is we provide an information of the pending Hague file to the local court, stating that please freeze the proceedings until the return case is over. So what happens is either local divorce court waits, or change of a custody court waits until the finalization of the return procedures, or time to time, if there is a divorce case, the judge will separate the context of a file, will not continue the custodial part. However, the judge might proceed with the non-custodial points.
And thank you for your answer. And Mr. Yalçın, you have handled hundreds of cases in this field. And may I ask, what was your most difficult case?
Well, it's a challenging question. Of course, each case has a different spirit, so has a different aspect. I cannot tell one of these only. However, I had a case, the 3 children were abducted to Armenian border, Doğu Beyazıt, and we went to Ağrı and Doğu Beyazıt courthouse, and of course in such small cities there is no family court, so there is only one civil court, and this civil judge needs to deal with all civil law procedures. So there was a new judge just appointed from the intern. We went to courthouse and met her, and the abducting parent was a member of the local clan. So the whole family was around 6,000 people. So we were under big pressure in that file. Thanks God we successfully won the case. But after this case, of course, I felt very different, because even though we won the case and the children went back to habitual residence country, for the maybe next 6-9 months, I couldn't come to office easily, because in the end of the day, in the application of this convention, you take one of your parents' child back to habitual residence country. This doesn't mean that you change the personal visitation, you change the custody. No, this is always the mistaken part. But returning back to habitual residence country does not mean separation of the parents. No. In that file, I was trying to tell the father that he has to go back to habitual residence country from the very beginning. And in the final hearing, I said to him, okay, you see in the 3rd hearing, we got a decision. So the children will go back to habitual residence country. And if you would hear my voice on the very first meeting, and went back to habitual residence country, you wouldn't be worried about this. And this person was very angry against me, but I was telling the truth. So as far as I heard later stages, he went back to habitual residence country. He continued his aggressive behavior in that country. Now he is still in jail because of his actions against the mother and the children. So yes, I scared a lot after winning this case. It was very important file to me because we were fighting for 3 children's life in their habitual residence country, and they were living in a very small village without knowing what is going on. So it was a very touching and very emotional file to me. So this is one of the examples, but I mean, this is a very challenging practice. So I mean, in my past case experiences, I represented around 40 different jurisdictions, from USA to Japan, from Netherlands to France, from UK to Germany. So again, every case has different aspect. Every case has a different spirit. So you need to see the facts. You need to understand that the file is filed properly, because this is something as a counsel you have to make sure that you check the custodial arrangements properly, you check the habitual residence properly, you check the potential Article 13b objections properly, you check the age limits and time limits properly. So this is a very wide practice, so you need to be careful in each and every point.
Yes, and following up on that, when can a return request be refused?
Well, first of all, the non-completion of the procedural requirements. I detailedly explained this. And also Article 13b. Article 13b of the Convention, which underlines the grave risk. If the return of a child will result a grave risk on child's psychology or child's life, then the local court might not decide in favor of return. So the case would be dismissed if there's a very serious risk of Article 13b. So Article 13b is the major point, break point on such procedures.
Thank you. And Mr. Yalçın, that brings me to the end of my questions. Thank you for your time and for sharing your valuable insights and experiences. It's been a pleasure.
Thank you very much. Again, child abduction and Hague 1980 is a very serious topic. My advice to parents is to carefully examine the facts. If there is any risk of abduction or retention, prepare accordingly. And in the event of having Hague 1980 procedure against you, please make sure that you have a proper advice. If you want our support in that, please feel free to reach me via info@yttlaw.com. You can also Google in or check in our webpage, or you can directly send a message by replying to that video. And please also don't forget to subscribe to our channel.
Yes,
and have a great day. Bye-bye.
Have a great
Bye-bye.
day.
Bye-bye.
Bye-bye.